Welcome to this video tutorial on bringing evidence on record. You are learning Law of Evidence for young lawyers. In the instructional material, we have learned and focused on the principal concepts of evidentiary law. In this video tutorial, we will revisit some basic fundamentals of evidentiary law. Before you proceed with the video, do keep some paper and a pen with you so that you can take notes as you watch through. You know, evidence is of different categories and each type of evidence has different evidentiary value. In the process of the adjudication of the matter, the evidence has to be admissible in the court and correctly appreciated by the court. But for the court to evaluate evidence, the evidence must be first presented to the court. The process of presenting evidence before the court is also known as bringing evidence on record. As the term suggests, this process merely brings the evidence to the court's notice. It is still the prerogative of the court to adjudicate upon the admissibility and evidentiary value of the evidence presented. The civil process and the criminal process have different methods of bringing evidence to the court's notice. Let us take a look on both these processes. Let us first look at civil proceedings. The Code of Civil Procedure 1908 regulates these. As you know, the CPC lays down rules for the creation and filing of pleadings and documents supporting such pleadings. As you gather from the provisions, it's important to clearly state the evidence relied upon to make a particular statement before the court, whether it's in the plaint or in the written statement. By doing so, you will bring evidence about the facts or statements on the court's record. After the evidence is clearly stated in the pleadings, it is subjected to judicial scrutiny during the adjudication process. Here, the court will first evaluate the admissibility of the evidence to ensure that it is permissible. Once the evidence is admitted on record, the court will check its evidentiary value before proceeding to rely upon it in the adjudication process. As you can gather, it is the hallmark of an efficient attorney to bring on record relevant evidence. The need to lead relevant evidence correctly stems from some important features of our judicial process. In India, the adversarial system is being followed. Under the system, the judiciary is arbiter that balances competing claims by multiple parties in the context of truth. Thus, it's not expected of the judiciary to seek information on its own accord. The judiciary only adjudicates matters placed before it by the parties. In inquisitorial systems followed in many countries, the judiciary plays an active role in investigating matters and seeking evidence independently. In the recent times, this trend has picked up in India, especially in cases of public interest. Second, it's expected that the attorneys know their client's case inside out and will be keen to build the best possible argument in their client's favor. Third, it's the fundamental principle of law that the best evidence of a matter will be presented before the court. It is not only a principle of law, but of equity that parties to a dispute should rely upon an agreed framework of evidence and facts. Keeping this in mind, parties are not allowed to spring surprises on each other at the later stage of proceedings by bringing on record evidence that they had not previously brought to the court's attention. This should explain the need to bring evidence on record, especially in civil proceedings. Let us now take a look at the criminal process. In criminal matters, after the commission of an offense is brought to the knowledge of a law enforcement mechanism, the investigation into the offense is carried out. As you are aware, based on the information gathered by the law enforcement authority, the offense is then brought to the notice of the judicial process. Once this process is begun, the investigation into the offense is closed and all the information gathered about the offense thus far is placed before the court. Here, the fundamental principles of equity and equality of all people step into the picture by requiring the judicial process to inform the person accused of a crime of all information and evidence that has been brought before it. It's because of this basic right of a fair trial that it's imperative for the accused to be provided. First, the right to question all evidence that is being brought on record against him or her, and second, to lead all evidence at his or her disposal to prove his or her innocence. Since all requirements are mandated by law, it's necessary to bring on record all evidence that pertains to the offense, whether by the prosecution or by the defense. This process is meant to provide an independent trial of an offense where the accused is presumed innocent until proven guilty beyond all reasonable doubt. Because the threshold for returning a finding of guilt is so high, the process applied to the admissibility of evidence in criminal proceedings must be stringent and applied rigorously without exception. Therefore, you can see that while it is critical to understand the process of bringing evidence on record, such an action has vastly different repercussions in civil and criminal proceedings. Most importantly, in a trial process, whether civil or criminal, it is critical to bring relevant evidence on record since it is not permissible to add new evidence to the matter should it reach the appellate stage. This is because under civil and criminal law, appeals are reserved to address matters of law and not matters of fact. Therefore, to ensure that a party has the best possible opportunity to establish its case at the trial stage, it's necessary to focus on bringing the correct evidence on record at the right time. You will be aware of most of these concepts under various subjects such as constitutional law and even human rights. But to truly appreciate the art of evidence, it is necessary to take a step back and understand the larger framework within which it operates. To sum up our discussion, bringing evidence on record follows different processes in civil and criminal proceedings, but is underpinned by the same principles of a fair trial by an independent judiciary and needs to ensure that the truth is brought to light in all matters. With this, we come to the end of this video tutorial. Do attempt the mock test accompanying the module 1 before proceeding to the next module. Thank you for watching.